Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 p.m. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere to let the conference see the light of day again, and at the same time to show compassion and empathy in our community. Let's watch the show together. It was this experience that became the spark for us wanting to help more people. We approached charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. Tonight, we will watch session 4, where our experts talk about the common challenges in variation order claims and how to overcome them. Also, if you have watched yesterday's show, we had a brand new content that was exclusive just for this charity premiere, and we did that again tonight with a special presentation by Turner. Let the show begin.
Session 4 is proudly brought to you by our session partner, Turner International, a leading provider of projects and construction management services with a presence in 10 countries. Our moderator for this session is Mr. Ivan Liu, a partner and co-head of the Construction and Engineering Practice Group in Screen. His expertise lies in the construction industry, where he has appeared as lead counsel in arbitration, adjudication, and litigation proceedings on construction-related disputes. Ivan also regularly sits as arbitrator in both international and domestic arbitration. Without further ado, I'll now pass the floor to Ivan.
Well, thank you. Madeline. And welcome, ladies and gentlemen, to this session 4 of what has been a very exciting conference so far. The topic of our session today is common challenges in variation order claims and how to overcome them. Now, as you know, together with defective work claims, delay disputes, EOT disputes, and its corresponding loss and expense claims and LAD claims, variation disputes relating to variations are commonplace. It's what one would typically find in a construction project. Now, in this session, we will be discussing the entire spectrum of variation claims disputes, and we are to this end going to have three very eminent speakers, and they essentially they're coming from 3 different jurisdictions. So I think you're going to have quite a broad-based experience in terms of the various jurisdictions and what the position is on variations. We have a speaker from Malaysia, from Singapore, and from Australia. Essentially, the first speaker, Rodney Martin, who is a CEO of the Charlton Martin Group, will be talking about whether or not an instruction from the contract administrator is an instruction to vary the works. Then the second speaker is Anand Anthony. He's a director of Capital Consulting International from Singapore. He will be assuming that the instruction is a valid instruction, and that he will then discuss what are the legal and practical problems that arise from that. And our third speaker from Australia is Liana Chan. She's a barrister from 2 Selborne Chambers in Sydney. And then she will be discussing about the various dispute resolution mechanisms available to resolve disputes between the parties. So without further ado, can I pass you the floor to Rodney, who will then deal with the first topic.
Good afternoon, ladies and gentlemen, and thank you very much, Ivan. Good afternoon, ladies and gentlemen. Can you hear me? I seem to be showing as being muted. Could Ivan just indicate if he can hear me?
Yes, I can hear you.
Great, thank you very much. Good afternoon, ladies and gentlemen. And I'd just like to share my slides. Okay, thank you very much. Well, thanks for the introduction, Ivan. And indeed, I'm the speaker coming from a Malaysian perspective this afternoon. And I want to deal with the front end, as he said, of the spectrum, which is how the contract deals with variations and how those provisions may be disregarded or abused, leading to disputes and problems with variations. Due to the nature of construction work, variations are inevitable, and indeed we have provisions in the construction contracts which deal with them. I'm going to deal with principally 4 areas. Definitions which we find under the contracts which are relevant to variations, such as the definition of the works themselves, and then the definition of variations. Where the power to instruct comes from under the contract and how that is used and sometimes abused. Then the question of whether these mechanisms actually work, and assuming they don't, what can be done to improve the process and therefore avoid some disputes. So first of all, definitions under the contract. How well is the scope of work under the contract defined, and how well is the term variation defined? And I'm mindful of Dr. Nassim's talk a few minutes ago, which was excellent. And what I've done here is reproduce the wording under some of the Malaysian forms to see how these terms are defined. I notice more words are present than perhaps Dr. Nassim would like. Let's see, here goes. So under the PAM form 2018, works means the works described in the Articles of Agreement and referred to in the contract documents, and includes any changes made to these works in accordance with the contract. So there's reference there to the contract documents. If we look at the AIAC 2019 form, which many commentators would say is an improvement on the PAM form, it's very similar to the PAM form. We have a broader definition. Works, a more detailed definition. Works means the works described in the Articles of Agreement and are the whole of the materials, labour, plant and other things necessary and requisite for the proper execution of the contract as shown on the contract drawings and described or referred to in the employer's requirements, specifications, contract bills and conditions. So there we have express reference to those all-important documents which describe the works. So the works are as shown in the specifications, on the drawings and in the bills of quantities. And that's a very important point. Now, just quickly dealing with 2 other Malaysian forms, the government forms. Under the PWD government form, the traditional form, work means the work specified in the contract documents and shall include temporary work. So again, back to a reference to the work specified in the contract documents. We have to look at the contract documents to understand what the works are. Now, that is very important for variations, because in order to overcome some disputes about whether an instruction is or is not a variation, we have to first of all decide on what the works were, which may or may not have been varied. So if the parties don't know or don't agree or don't understand what the works were as described under the contract, then there's a problem. And therefore, if the contract documents are poorly drafted and are unclear, then we have major problems. And this is really one of the areas, certainly in my experience, where variations are most problematic, because the documents are poorly drafted for whatever reason. And this leads to uncertainty as to the original scope of work, and therefore arguments about whether an item being claimed is in fact a variation or not. Just lastly, on the government form, the design and build contract, we have reference to the government requirements and the contractor's proposals. Now, very often the definition of the works is by reference to the government's requirements only in design and build contracts, but here we have reference to both of those documents, both the government's requirements and the document which the contractor put up in his tender, which is aimed to meet the requirements of the government. So we have to read those two documents together to understand what the works are under the contract. And if those documents are poorly drafted or unclear, then we have the foundations of many disputes in terms of variations. Now, I'd just like to briefly turn to the variation clauses in the contracts, the definitions of variations. Now, the PAM form started off as the 69 form, the PAM 69, which was really a copy of the JCT 63. And that form, the PAM form and the JCT, have evolved over time. And I think, arguably, the definition of variations is very well developed now in this contract, as with many current standard forms in their current forms, because improvements have been made along the way. So the classic words we see for variation as a definition are alterations or modifications of design, quality, or quantity of the work. Those are the key words usually: the design, the quality, or the quantity of the work. And then we've got some add-ons here in the PAM form. For example, 11.1c, the removal from the site of any work executed or materials and goods brought thereon by the contractor. D, any change to the provisions in the contract with regards to limitations of working hours, working space, access to or utilization of any specific part of the site, the execution and completion of the works in any specific order, and the execution of temporary work. So the drafters of PAM in its current form have added on and expanded the definition of what a variation can be, not only in respect of the permanent works themselves, but in the way in which the work is carried out. Now, the right to vary is a very important feature of most construction contracts, giving the employer the right, without having to go to the contractor and reach agreement every time, to unilaterally vary the works. And it's very important. And here in the PAM form, we can see that that right has been taken to more areas than just the actual physical work, but also to ordering how the work is carried out, which traditionally, before these type of forms came out, was very much the domain of the contractor. He had to carry out the work. How he did it was up to him, and there wasn't the right to vary the contract, the scope of works, in terms of the manner in which the work was carried out. So we can see a very well developed and detailed variation clause under the PAM form. AIAC, again, because it's very similar to the PAM, have got similar provisions, but not quite as extensive as the PAM form. I'm not going to go into the detail, there isn't time to do that. PWD, the term variation means a change in the contract document which necessitates the alteration or modification of the design, quality, or quantity of the works. I'm sure Dr. Nassim will have something to say about what that means. Not terribly clear, but we get the idea. Alteration or modification of the design, quality, or quantity of the works. Where the contract document comes in, I'm not sure. And again, addition, omission, and substitution. This is the classic definition. So nothing unusual there. And then finally, under the PWD, the design and build contract, the term variation means a change in the government's requirements. So that's very important that the government's requirements are very clearly set out. And this is an area of dispute, not just in terms of variations, but generally in terms of scope, in design and build contracts, and I've seen this in Malaysia and many other countries, where it is argued employers take advantage because the wording is unclear, and they say, well, it's a design and build contract, you shall provide what I want, whether or not it's in the contract. So disputes arise. Far better to avoid disputes and be clear on the original scope, whether it's a design and build contract or otherwise, and set out in clear terms what the work is that's been tendered for and is to be constructed by the contractor. Anything beyond that would be a variation pursuant to the mechanism under the contract. So what can we take away from looking at those definitions? First of all, the definitions of works and variations in standard forms are adequate. I would say, looking at the forms I've just looked at, there's nothing wrong with the wording there. It's how the parties use or misuse or abuse those words is the problem. They've evolved over time, and these provisions are now well drafted. I would say, it's fair to say, in my view, but those preparing drawings, specifications, and BQs must work hard to ensure the scope of work described under the contract is clear from the outset to avoid disputes covering what is or what is not a variation. Moving to the second area, power to instruct under the contract. Where does the power to instruct variations come from? Well, usually this is delegated to the certifier, the architect, the engineer, or the SO, and he may have his wings clipped, so to speak, in terms of financial limits. Particularly in government contracts, the SO is often limited to the value of variations which he can instruct. That always amuses me, because very often the actual value of the variation is unknown, so he must rely on some kind of estimate to decide whether he's breached his authority or not. Should, of course, be in writing, ideally in a prescribed form for transparency. Now, this is one of the problem areas, because if a drawing is issued by an engineer or an architect to deal with one of the errors he's had in his tender drawings, and he doesn't admit that it's a variation, then there may not be clarity from the outset that this is being acknowledged as a variation. However, if that drawing is issued under cover of a document which is called an architect's instruction for a variation, as we see perhaps in the Singapore form, SIA, which is very clearly it's an instruction for a variation, or it's an instruction to comply, then there's less area for dispute and uncertainty. So we need clarity, and we need honesty, and we need those who are administering the contracts to own up to their mistakes if that's the cause of the variation instruction, and deal with the issues as they arrive, and be clear communicating the need for a change for whatever reason, whether the employer's changed his mind or it's an error that has to be corrected, etc., needs to be dealt with, or perhaps an error in the documentation, the bills of quantities haven't been prepared properly. Some contracts have clauses to deal with those situations. So there is this conflict potentially between the certifier, who is also the designer. If employers step in and issue instructions without respecting the mechanisms under the contract, that's also a big area of problem, because in fact the employer may be entering into a separate contract and won't be protected by the valuation mechanisms under the contract, where a variation is properly administered and issued under the contract. So the employer must respect the fact that he's effectively delegated the certification, the issuing instructions for variation role to the certifier, to the contract administrator. Next, do the mechanisms work? How does the mechanism break down, or is it misused and abused? Well, I've mentioned some of this already. Lack of certifier's clarity when issuing the instruction. That might be an innocent failure to draft and issue instructions clearly, but very often there can be a reluctance on certifiers to withdraw or clarify instructions. So there needs to be certainty initially in the contract documents and subsequently in the contract administration documentation, which is issued under the contract. Lack of clarity within the details of the instructed variation itself, another issue, another area of concern. Lack of discussion. In the previous session over lunch, which I found extremely entertaining, Engineer Harbins saying parties, everyone should talk more. And this is very much the case when a variation is being contemplated under a contract. Instead of issuing an instruction, which may or may not be as clear as it could be, the parties ought to discuss the need for change in the regular meetings between them, so that the parties are kept aware of the potential for change, and the contractor can plan accordingly. Time under contract variations is going to be dealt with in the next session by Anand. Failure to act expediently, thus causing delay in terms of the administration of variations, is another way in which the mechanism can break down. The fact that the instructions aren't acknowledged at all, or they're late in being advised the contractor, perhaps the contract administrator considers the contractor is in delay and doesn't need to receive the instruction until later. Often not the case. The contractor needs to know what is changing as soon as possible and as clearly as possible. And it would be useful for the contractor to be engaged in the process of considering variations early on. He is, after all, the one planning how the work is going to be constructed. So to change that work, he is fundamental in the process of how the change is actually carried out. And a failure to ascertain likely cost and time impact of the changes is another area of concern where disputes arise. Not acknowledging that the variation could actually have a time impact, particularly. Cost is often dealt with under the valuation clause, but not having the ability to consider time with the contractor involved in that conversation is a lost opportunity in my view. So better to engage the contractor in the process when variations are being considered, and that variation could sometimes be avoided or cancelled if the contractor had been consulted and the process could be considered with his input. What can be done to improve the process and avoid disputes with variations? Well, I mentioned at the beginning, clarity at the outset on the agreed scope of work requires the contract documents to be drafted carefully, properly. Many consultants, particularly in Malaysia, often complain that they're under great pressure. They're not paid enough. Employers don't respect and understand the professional services they're providing. But these excuses have to be overcome. And really, many of us in the industry who deal with disputes, the quality sometimes of the documentation is shocking, and improvements must be made. And I'm not just talking about Malaysia. In many countries in the region, the documentation is substandard, and that obviously leads to disputes. So the better the documentation, professionally prepared, considered from the outset, the fewer disputes there'll be on the scope of work. The pre-agreement of time and cost for variations, especially where the variation is considerable and will have a significant impact on the works, would be desirable. And transparency on the part of the instructor to explain, to pre-discuss, and to engage with the contractor to avoid disputes on variations would be helpful. So in conclusion, construction contracts are adequate if prepared correctly. Poorly prepared drawing specifications and BQs will lead to disputes. Contract administrators must do their job and must not abuse the power or the process, and agreements in advance, especially on major variations, are desirable. If these are all practiced, I believe there will be less problems with variations. That's all I have, ladies and gentlemen. I'll now pass back to Ivan to continue the session. Thank you very much.
Well, thank you, Rod. All right, so Anand, we have now a situation where, assuming that the instructions have been given correctly to vary the works, so it's a valid VO. What are the practical or legal problems that one might face in situations where they end up in a dispute?
Right. Thanks, Ivan. I'm going to start to share my. Everybody seeing a full screen? Can everybody see my slides? Right. Can I take it all? Can you hear my slide and see me? Is that all right? Great. All right. For my session, I'm going to start off by just continuing from where Rod started. But I'm going to assume that there was no issue with the variation in terms of everybody has accepted that it is a variation. So I'm going to share from a time perspective, because from my experience in the last 32 years, often one of the big fights about variations is the timing of the variation more than anything else. And so I'm going to share with everyone variations which are time-based, variations where the site conditions have changed or some things have changed, and lastly, where the contract conditions have changed. Now, I'll start with time-based variations, where often occurs when the variations are issued when the project is running midway and then instructions come in. Now, often the first objection comes from the contractor in that the contract rates from the BQ or the rates in the schedule rates quoted are quoted so much earlier on the job. They are low, they cannot apply. Either way, no matter what rates we're looking at, if we're looking at that, means we're going to end up doing the variation works at a loss. Now, quite a common dispute area when I do my quantum expert work, often big fights. Now, I'm throwing this to the floor. I see this as legal because whether or not the contractor is bound by these BQ or SOR contract rates. Second question, probably for the lawyers to look at. Is a contractor obliged to do variations at a loss? Now, leaving that hanging, I'm going to give out some suggestions. Right? I may not have all the answers, but some of my suggestions. Now, when an instruction for a change order or variation order comes in, the very useful tool actually is the program. But this is what I've seen from both small contractors and large contractors alike. Very few, if not none, in my last 32 years actually use the program to show the relationship between that instruction and where they are on the works. They don't show it. And when they don't, all they do is keep arguing and bickering, and sometimes it goes into a shouting match at the so-called site meetings or progress meeting forum. The other thing is this, most contracts actually allow for new rates or what contractors call star rates, where no identical contract rates can be used. Now, this is usually a tussle between the employer's cost consultants or the employer's quantity surveyors and the contractor's side. Because one of the things that a contractor must do is demonstrate that this provision must apply in this situation. Now, once they've done that, actually it makes it easier. But the starting point really is the program. All right, now let's look at the variations when the site conditions have changed. Now, one of the common arguments by contractors when they talk about site conditions being changed or different from when they quoted in the tender or in the quotations is the site is now very congested. It's very different from when we quoted, we were looking at doing our works where we had an ample space, we had full access, there were not many other contractors or there were no other contractors in the area. Or we are encountering different conditions. Now, common dispute, very common dispute, nothing new. Now, looking from a site condition changing, again, the missing element is really the program. Now, the other thing that I see that's very, very lacking, despite the fact that almost all the construction contracts I've seen from UK, Europe, Hong Kong, Singapore, Malaysia, and Australia and elsewhere, most construction contracts actually allow for the use of quotations where you don't have a similar like piece of work or, the contractor says the situation is different. And one of the things I have used when I get called in as an expert determinator or as a neutral onto a project to look at the dispute between the parties is to ask each party to look at it if the same situation had occurred at the tender stage. How would you each look at it? And sometimes that gets both sides to be a little bit more realistic. All right, that's my experience. Third one, where the contract conditions have changed. Now, this one here, I've seen such situation no less than at least a dozen times in arbitration alone, never mind anything else. And that is where the instruction results in the contractor having to literally terminate the existing subcontractors or trade contractors because they can't carry out the new instructed works. Now, I'm using a very simple example where midway through the job, the employer decides that I don't want to see homogeneous tiles on my floor and wall finishes. I much rather see stonework, marble or granite. Now, I've been through many such situations, both working on the contractor side, working on the consultant side, and working on the subcontractor side. Never an easy situation because the main contractor now literally has to go to the subcontractor and talk about termination, because the subcontractor cannot carry out the stonework because that's not his trade. Now, in a situation like that, it's not an easy one to deal with, not in the middle of a project. And the bigger problem really is this. It's the position both parties take when this is brought up. The employer sees this situation as the contractor's internal problem. The contractor sees this as an employer-caused problem. Again, solution, show it on the program as to where this situation really is from a realistic viewpoint. I'm going to jump ahead. I'm not going to step onto Lena's next session, but really from my perspective, and I've seen this many times, this is where the met up kind of dispute resolution seems to work, to get parties to see things really from the area of interests rather than just anchoring their own particular positions. Now, I want to share a little bit about the programs and why I'm as coming from a delay and quantum viewpoint. The program really is key to explaining when and where and why is it that the timing of the variation is really the issue. Because I've seen in too many times in the last 32 years, contractors or subcontractors saying these exact words. Had I known this 2 years back, I would not have responded in this way, or I would have done X and Y or Z or whatever it is. And it really talks about timing. So it's not really about cost, but timing. Now, to begin, a lot of contractors don't use softwares for programming. I've seen very, very large contractors, while they have got the Primavera in their submitted programs, don't actually use it to monitor the works or update what's going on at all. Generally, the expectancy is actually, if you have a level 5 program, that means every bar line is less than 10 days. It makes it easier to have a proper breakdown of the works. I usually prescribe and advise contractors, consultants, and the client side, have your main scopes for every trade broken down to 10 basic activities. Planning to the design stage, when you need approvals, how long you need it, when your material orders are going to go out, when you expect the materials to get delivered, fabrication time, then when you deliver the fabricated materials back to the site. Surprise, surprise. Most contractors' programs only tend to focus on activity 8, and that is the site installation works. when in fact, when variations are instructed or changes are instructed, the impact starts from activity number 1. It affects your planning, it affects your organizing of your works, right down to design, approvals, and down, it just pushes back. Activity 9, testing and inspection, handing over and punching list, right? So resource the program, so it helps when the consultant side or the employer side is asking the contractor, look, you now say you need more men, but what is your original plan to resource in the first place? And very often the contractor doesn't have an answer. He really doesn't have the answer, and that's the truth, because he never had a resource program, or he didn't think too much about it in the first place. Now, what helps is if the program is always tied to the method statement of working and the resource histograms, which is very rarely done. All right, so in a nutshell, if I were to try and just draw a very simple illustration, if you have a planned work and you're working to your plan, and then this instruction comes in, you can easily show it by now where you are versus when this instruction comes in and what is going to now start to shift. And which are the activities that are going to be impacted by this particular instruction. And then you can give your forecast of what is going to likely happen if this instruction now is going to take shape. Now, in a simple illustration, actually, it is easier than having the parties fight and bicker about what should or should not have happened in the first place. I think my time is up. And yeah, I'll pass it back to you, Ivan.
Okay, thanks, Anand, for that very much. Okay, Elena, so we have now a situation where, Anand has raised all these practical problems that eventually may lead and will probably lead to legal problems. What are the dispute resolution mechanisms around that can assist parties in resolving these disputes?
You're asking me?
Yeah, that's right. Sorry.
Yes. Yesterday I was having a look at the Malaysian landscape and to see how Malaysia approaches dispute resolution. And I found that mediation, according to the commentators anyway, is not popular in Malaysia. And when I listened to the speakers this morning, there is an overwhelming sense that mediation is not really the most popular method of dispute resolution. Now, I wanted to focus on that because I only have 15 minutes. Under the PAM 2006 contract, matters can only go to arbitration after practical completion. But before practical completion, the options are adjudication and mediation. And the adjudication is final until the completion of the project. And after practical completion, there are time limits in there for which notices for arbitration have to be given. But for all practical purposes, while the project is ongoing, the only real method of effective dispute resolution, in my opinion, is a negotiated outcome. Now, when I practiced for a very long time, and I found that, in my experience, many lawyers approach mediations in a very adversarial way. They show up to a mediation and they treat it like a mini trial. They do not want to share information. They're very adversarial, they're very antagonistic, and it's a very distrustful kind of environment. And so about 3 years ago, I decided that I needed to upskill. So I went along to Harvard Business School and I started my Certificate of Management Excellence. And one of those modules was deal making. And from that, I have learned, and I have been applying that very successfully to my matters to resolve. I think in the last 2 years, I've resolved about 20 matters by negotiated outcome, including those matters that had been to mediation and had been unsuccessful. Now, the primary thing the point I wanted to make, which Anand highlighted, is that when you approach a negotiation, you've got to think of it as an interest-based negotiation. So the parties have to work out the interests of both parties. And I approach my negotiations with a lot of preparation. It's almost like I'm preparing to go to trial. Before a negotiation, I will call a strategy meeting, and if there are technical experts involved or my clients involved, and generally I work for insurers, the insurers will be there. I'll invite everyone along to my strategy meeting, and we will all sit there and we will work out all the, we call the BATNA, which is the best alternative to a negotiated outcome, and WATNA, which is also the worst alternative to a negotiated outcome. And in that meeting, we work it all out. We work out what our best points are, what our weakest points are, what our zone of possible agreement is, and for both my side and for the other side, so that when I actually show up at the negotiation, I'm completely prepared. I know what our interests are, what the other side's interests are, and I treat it most of all like a relationship building exercise. I do not walk in there with an adversarial approach. And there's research that has been done by Harvard Business School, which shows that if you walk into a negotiation and if you just walk in and shake everybody's hands and you get everyone in the room to shake each other's hands, then the odds of actually being able to resolve the dispute at the negotiation is highly increased, because it puts everyone into the right frame of mind. So people are always saying, before I went to Harvard, people were always saying, it's a win-win situation. It's you're increasing the size of the pie. I never really understood that. And when I started my program, I kept saying to the professors, but how on earth do you negotiate with unreasonable people? And the professors kept saying, they're not actually unreasonable. And I didn't really understand what they meant. But as the week wore on, because it was a full-on 24/7, 6-day course, I started to understand what they were saying. Because sometimes when what we perceive as the other party being unreasonable is not actually them being unreasonable, it's because we haven't really taken the time to work out what is actually motivating them. So for example, in some of my cases, even in commercial cases, there generally are commercial cases, we might think that the plaintiff has a hopeless case. There's no way the plaintiff is going to win. Their claim is completely hopeless, but they refuse to settle, and they are just intractable. And prior to Harvard, I would think, my God, that plaintiff is so unreasonable, and there's just no way we can settle this matter. But then after I did this course and I read every single textbook available on negotiation, I worked out that I actually have to work out what on earth is bugging. I need to work out what is bothering this other party. And sometimes, even in commercial cases, it's because that particular party feels that they have been cheated. So you might have a situation where the contractor might feel that the principal has misled them because they haven't given them the full picture, they haven't given them all the geotechnical documents, etc. They've withheld some kind of information from them. And the contractor might feel tricked, and they have lost trust in the principal. And so a variation claim may be made, and everyone might show up to the negotiation, and the contractor might appear to be completely unreasonable and might appear to just reject offers that may seem to be completely reasonable to the owner. And I've had this happen before. And when I have worked out, and this will have all been done prior to the negotiation, where I sit down with my entire team and we go through all the evidence and we work out what on earth is it that's bothering the contractor. And sometimes it's because the contractor feels tricked. And so in my negotiations, I've had situations where there's no trust between the other parties, but if you actually drill down into the detail, you'll find that nobody was actually trying to trick the other party. It was a genuine mistake. And so when that happens, I will sometimes lock the parties in a room alone together without the lawyers and get them to clear the air. And sometimes that might take more than 1 or 2 goes, where they actually have to, get to the position where they each realize that the other side has not actually been trying to trick them, but they're actually all working towards the common goal of getting this project delivered. And so that's what it meant by interest-based negotiation. So it's not just about showing up to a room and saying, hey, we've got to talk to each other. It's not about just talking to each other. You've got to talk to each other with always realizing that at the end of the day, you are all there to deliver a successful project. And if you don't, and that's the common goal. So when some of the other speakers have said, you need to discuss with each other as the project is going along, what is happening, if variations have to happen, that has to come from the project director. Because for example, in Sydney, we've been building the WestConnex, this very wide system of roads and tunnels, etc. And the project director said to me that, I treat it like we're basically a team and we're actually running a business, that that is my job as the project director. When something I see is going to go wrong, or we're going to, hit some kind of roadblock and I'm going to have to accelerate the works or make changes, etc., I actually call a team meeting and I have everyone working together so that we can all come up with a solution together. And so he treats it like a business. So and it's not an adversarial approach. You have to work together because you're all working towards the common goal of trying to get this project delivered. And of course, then you have to follow it up with proper documentation, etc., because you do at the end of the day have to comply with the terms of the contract. But it's a different mindset of not us and them. And it's not, and the PAM contract, which I think personally is well drafted, it's very clear that they do not want the parties to be going to arbitration midway through the contract. And that really doesn't work either for relationship purposes, because I would assume that many of the parties might have ongoing relationships, and this might not be the only project they're going to be working on together. And so it would be important for them to be working in a collaborative way the whole way through, and put aside the adversarial approach, and to constantly realize that they're all actually a team. And that has to come from leadership, and that leadership has to come from the project director. Now, when you're preparing, I think it's very important to notice, you have to look at the facts, you have to look at what's going on, and you have to notice better. So the people talk about sunk cost fallacies and, looking for confirming data, etc. You've got to have a really open mind. So one of the examples that were taught to us, for example, there was a company, this is a real story, it was a company negotiating for the chemicals, for the exclusive right to some chemicals to make anti-dandruff shampoo. And so the team were negotiating with the people who actually made these chemicals, I think it was in Italy somewhere, and the suppliers refused to provide exclusive dealership, exclusive license for this chemical to the purchaser. And it was a huge negotiation, and the negotiator had left and he had gone back to America, and they hit a roadblock and they just could not get past this point because they couldn't work out why a fantastic offer for this product was not being accepted by the supplier. And so they called the negotiator back from America, and he went into this negotiation, and all he did was ask the supplier, why won't you give us, why won't you accept our deal? What's the roadblock? And this supplier said that, well, it's just that we promised this little family company down the road that we would give them X liters of this product every year. And so that was the roadblock. And they said, for that reason, we couldn't give you an exclusive deal. And so what they did was ending up agreeing that every year they would be allowed to still supply this other company this certain quantity of this product, but the rest of the product would be sold to this company. So, what's really important is, I find that when you go into a negotiation, you've got to put aside the adversarial approach. You've got to share information. I share information. And when I started doing this 3 years ago, it was met with a lot of suspicion. People would say to me, why are you asking questions? Why are you issuing interrogatories? You didn't give us a list of the questions we were going to ask before. But that's just ridiculous, because we're in a negotiation. And so what I do is I go in there and I share information. I'm completely open with them. And then in return, eventually people always get on board. And I find that in the negotiations that I do, there's a change in the energy of the room about maybe halfway through, there's an energy in the room and everyone gets on board. And if you can feel that shift in the energy, then that's when you know the matter's actually going to settle. And of course, sometimes when you're doing this, it doesn't feel like you're ever going to be able to get to that point. But if you keep on having an open mind to it, then I find that it has been successful. So I find that, I also some people think, oh, don't ever make the opening offer. Don't make the opening offer because you're going to come across as weak. But I disagree. If you make the opening offer, then you've set the anchor. You might want to set it really low, or you might want to set it really high. So, but if you make that first offer, you've really anchored the negotiation, and then that will set the tone for the rest of the negotiation. And also, when you're making an offer, don't just say, I offer you X dollars. You should tell them why, tell the story that goes with the offer. And so in some of the mediations that I do, in some of the negotiations that I do, I will, prior to this, we would just be passing papers back and forth, and it might be going through the mediator. But now, we always make sure that we were giving the offer to the other side. We do it face to face with the other side. Whether or not the mediator is there is another point. They can be there, but we always want to speak to our offer, and we want to, it's all about relationship building and explaining where you come from, because at the end of the day, you're there to resolve a dispute in a way that both parties can best live with. So it's not about mindless haggling. There's no point in adopting a position and then have both of you just go, no, X dollars, the other side goes Y dollars. That doesn't work. You've really got to explain to the other side where you're coming from. And I know some lawyers think, no, it's not just about that. It's just about getting to a number that, both parties can live with. But in my experience, that doesn't really work. And for me, it's about, the steps that I have explained to all of you. So at the end of the day, you have to be flexible and be honest. So don't forever, ever, give ultimatums if you don't mean them. If the other side gives an ultimatum that ultimately will be embarrassing to them, you just ignore it. But obviously, sometimes it does get to a point in a negotiation where, you have to say, this is my best and final offer, but you never say it unless you really do mean it. So at the end of the day, the one thing I think you can take away from all of this is, in my experience, if you approach a construction project like it's a business where everyone is working together to have towards a common goal, and that you approach disputes in a collaborative way where people are discussing their interests and working together to come up with a workable solution, then that will work, because I have found that it worked. And when I was at Harvard for the first few days, I just kept bugging them. I said, but I don't understand. I just don't understand how you can negotiate with unreasonable people. And they kept saying to me, they're not actually unreasonable. And it wasn't until maybe the 5th or the 6th day that I finally got it. We finally got to the part of the curriculum that actually explained to us that really it's about unfreezing people who have gotten into this position, and you can only do that if you can work out why it is they're in that position, and then you have to address it. And in every single case, whatever is causing the other party to freeze can be different, but every single case has to be approached on its own basis, and you have to do the homework to work out what it is that is causing the other side to take a particular position, and you have to work out the way, whatever it is. And it's for you to work out what it will take to unfreeze them from that position. So I think, Ivan, is my time up?
No, you're good. I mean, if you need to say something more.
Yeah, I did this PowerPoint, which I might just get Cindy to share with everybody because it's really good. It's very pretty. I'm just going to share it quickly. You can see it. So I just quickly go through the PowerPoint where it identifies the various contracts and where the dispute resolution procedures are, the terms are there. And I quickly deal with, I highlight a couple of cases that make it very clear that you have to comply with the dispute resolution procedure in the contract before you, no matter what you do, the point is you can be collaborative and you should be collaborative, but you must never forget the contract is still there and you always have to comply with the terms of the contract, because if you don't, then you might find that you've been blocked out of arbitration, etc. down the track. So for me, what the interests are is really this certainty and speed of, dispute resolution. And for me, I think that comes from reaching a negotiated outcome. When I first started as a lawyer, I worked for some judges in the Court of Appeal, and judges said to me, now that we've been in practice for so long and have been on the bench for 10 years, we now think that the best way of dispute resolution is via mediation. And of course, and now that I've been practicing for so long, I've reached that point too, because you can find so often that when you are in an arbitration, your opponents might treat it like litigation. And so everything is dragged out, every point is taken, and it's just not efficient. And so much costs are incurred. And really, at the end of the day, the only winners are really the lawyers. They're not really the clients. And this delay is just a nightmare. Whereas if you, and of course, these are the pros of arbitration, which everyone knows about. And they're undeniably there. But I think that when you are in the middle of a project, the best approach really is to try and negotiate an outcome for yourself. And so the points that I wanted to go through, I only was able to pick up some of them, that what you get through mediation is certainty, speed, we have non-financial outcomes, and we increase the size of the pie, because if you can maintain that good relationship with each other, then it's more likely than not you'll be able to work on the next project together. And so these are the steps that I think that everyone should do before a mediation. You call your meeting, you've worked out your strategy, and you have to, as I said, notice better. Then during the negotiation, here are the things that I think that you should be doing. And most important of all, everyone always laughs when I say to my team, you've got to shake hands with the other side. And honestly, in every negotiation that I've done where we shake hands with the other side, I think we've settled 20, I think out of 23 cases that I tried to settle in the last 2 years, we settled 20 of them. And so here, as I said in point 3, you make the opening offer, you anchor the offer, you sell the story. And when you have a concession to make the concession and label the concession. So, it's okay. You don't have to treat it like an adversarial process, but even in court, even when we're making submissions to the court, sometimes it's appropriate to make the concession to the bench. If you have a weak point, make the concession. I do, because that way I have found, then you get the confidence of the judiciary that you will not take useless points. And when you don't have a good point, you acknowledge it. So the point is, we have to be flexible, and first impressions matter. And I made the point about stubborn, untrustworthy, and unreasonable people. As I said before, some who you might perceive to be unreasonable may not be unreasonable, but if they are untrustworthy, if they really are untrustworthy, and for a fact that these people are untrustworthy and cannot be trusted, then you do not negotiate with them. And they made that very clear in Harvard. So, we just do not, you cannot reach a negotiated outcome if you are negotiating with untrustworthy people. But in most of the times, I think in 99% of the times, the other side is not untrustworthy. Something else is motivating them, and it's your job to find out what it is. And I already made the point about ultimatums. Don't make them. And at the end of the day, don't walk away from the negotiation. If it's unsuccessful, don't walk away without understanding why the negotiation was unsuccessful. You have to know why. And as I said before, do not lie, because honesty is the most important thing. And afterwards, if your negotiation has been unsuccessful, then you should always follow it up with an email to the other side to set out your understanding of where the negotiation was left, and both from your point of view and from the other point of view, to keep the doors open, because, you know, ultimately down the track, you may be able to negotiate an outcome for your dispute. So
thanks, Lina. Sorry to cut you off, but I think if we have about 15 minutes for discussion I see that there are some questions coming from the floor as well. So maybe we could go through that, and maybe we can come back to you, Lina, on some of the issues that you have raised as well. Very interesting. Thanks very much for that. So we've heard from all our three speakers. Thanks, Lina. We've heard from all three speakers. And I think I just wanted maybe to quickly go through some of the, I mean, I can't go through all the questions that have been asked by the floor, but I thought maybe I could start with something that came up actually during session 1 by Raj Nabaratnam. He was suggesting that perhaps the issues that have arisen due to the pandemic, the SOPs by the government, perhaps that could be treated as a variation as well. What does the panel think?
Perhaps I could start off,
yes.
Ivan. I also got that question as well, and I thought about it when Raj asked it. I would say that it depends on the definition of variation under your particular construction contract, and whether the government directives, the various MCOs, or whether COVID is a potential force majeure event would come under the definition of variation. So the starting point, do I have a variation because of these circumstances? Go back to the definition of variation under the contract. That's under the contract in terms of varying the scope of work. Then there's the potential, which I'll pass to Lena, of a variation of the contract, which is a different thing altogether.
Yeah, that's right. I think when one talks about variations in terms of how it works, one normally talks about somebody trying to add something into the works, addition to the works, or an omission of the works. So it's like a change in the work. So when a suggestion, I think a valid one as well, it could, very possibly be a variation, but it's a variation potentially coming from an outside source. It's not from the parties, it's not from the employer. Essentially it's from an event, a circumstance that led to perhaps more difficult conditions in terms of working by the contractor. Perhaps they can't even work in view of not being able to get access to the site, that sort of thing. Does that really sound like a change in the works?
Well, it's a change in the way in which the work is carried out. And I know a lot of architects, when the first MCO came out, issued suspension instructions. And they may have lived to regret it, because in fact, that is an instruction under the contract which had ramifications for potential EOT and potential loss and expense. Had they not done that, then the position may have been different. And I think some of them even cancelled those instructions later on.
That's what happened in Singapore as well. Basically, most of the contract administrators refrained from issuing suspension orders under the contract, and the contractors wanted something like that in writing, but they never received them, and they kept writing in because of this COVID-19 situation. But the contract administrators took a position that this is outside our control. We are not the ones issuing these suspension orders.
Yeah, so Lena, do you have any experience in this, whether it can be considered a change order?
Doesn't it depend on the way the contract is drafted? I think it's a case-by-case basis of you have to look at the specific contract, see how variations is defined in it, and then make the judgment call.
Yeah, I think I agree with that. And in terms of the various contracts as well, I think it's, the PAM contract talks about a change in the provision of the contract. Whether a government SOP in relation to the pandemic, whether that can be considered as a change in the provision of the contract, I suppose is something that needs to be looked at by the courts in the event it gets there. So the other question I think that I've seen from one of the delegates is in relation to omissions. He talks about whether or not if there is an omission of, let's say, a third of the contract, a contract that's worth 92 million and a third has been taken off. He gives the example of you're supposed to build 3 buildings and one of the buildings has been omitted or cancelled. Would that be considered a variation?
Often there are arguments about this, and where the contractor is normally coming from is an economic position. He's going to lose money because the work has been omitted. Sometimes he might be happy because it's a loss-making contract and he hasn't got to do that. So often the contractor is motivated by that. Very often, of course, there will be a limit to what a variation can be. And I would say a third of the contract going would be a valid variation because the contract contemplates variations, and subject to a comment made earlier this morning about loss of profit. If the reason for omitting the work is to give to somebody else, then that would be considered in most jurisdictions to be an invalid variation because the contractor has the right to do the contract work. So there will come a tipping point when the variation would become an invalid variation. But that's, as Lena's suggested, depends on the circumstances of the project and the contract and the definition. Without sounding too much like lawyers, avoiding questions, it does depend on the situation. But there's no reason why to take a third of the job away would mean it's an invalid variation. It would be a valid variation in my view, based on the usual definitions of variation under the contract that we get.
Okay. Anand, there was a question that was asked again from the floor as well about you talked about programs being very important, and it's true. You do need programs. You do need to be able to establish, contractors need to be able to establish their case. But more often than not, construction programs, the programs are not part of the contract. It's not a contract document. It only comes after the contract has been signed. So does that make a difference?
Okay, I leave the legal part of it to you guys, the lawyers. But my view is this: we whether or not it is part of the contract or not, that's the legal issue. But from a practical viewpoint, the contractor's program is important for two reasons. Number one, it must show how he plans to do the work. The first problem is actually that, and that is the contractor's program, when most people open it up, cannot show and does not show how the contractor plans to do the work. Why? They're all simplified bar lines right across, and you can't read them clearly. And that becomes very, very confusing and very difficult, and often is the start of all the arguments which leads to disputes. And that is when variations are instructed. And like I said in my slide, it goes to the starting point of the contractor's work, planning, organizing the work before going into design, ordering of materials, and so on and so forth. But with the contractor, all he has is this one bar line for all of that particular one activity, let's say plumbing and sanitary or whatever it is. And this new instruction comes in and does affect it. How do you show it? Because it's very difficult if you don't have such a breakdown, right? And the second thing is the program is going to be used, whether it's a contract document or not. Like I said, I leave that to the legalese. Whether it's a contract document or not, it doesn't matter, because everyone on the project is going to use that program or the updated program, whichever program, for the purpose of looking at the monitoring of the job, as well as the claims coming in, and especially when the contractor gets pushed and he asks for extension of time, while the employer, looks at some older program and talks about delays and liquidated damages, but everybody is going to look at these documents called programs, right? My simple practical take is from my old lecturer, Dr. Dennis Baloo, who was the first project director of MRTC in Singapore. And his view, I think, is something I totally concur with. And the reason why the program or any of these programs should never be called a contract document is because most people assume that contract documents means contract terms and they should not be varied. And if you're going to be dealing with programs where contractors are changing them constantly, almost like how people change clothes, that's going to be very difficult, because when you change something that's called a contract document, some might perceive it to be a breach of contract. So it's just confusing. Leave it as something that is going to evolve, but at all times it must show how the contractor is going to perform his works. And with enough detail, you then, when new instructions come in or changes come in, or even this pandemic when it comes in, we can then see what are the activities being affected and how we can move forward from there, either to try and mitigate the situation, manage the situation, control, or even try and eradicate the worst possible scenario.
Well, I think in some instances, I don't know, maybe it's better for the contractor to have their program as a contract document, because then any change that the employer wants to make to it becomes a change in the work, and a change, and becomes a variation as well, in which they can claim an extension of time. And
I tell you my first-hand experience in Hong Kong using the NEC, where the program is part of the contract. Absolutely no. Absolutely no. All you get is one party on one side insisting on no changes being made on our accepted program because it's a contract document, and the contractor on the other hand saying, look, this instruction has come out, this has changed, you guys don't want to admit it, but this is exactly what's going to happen. And then, you know, there is a stalemate. So yeah. Is it helpful? I don't think so.
Well, I mean, that's an important point, I think, which leads me to a question, I think, for Lena. I mean, I think your presentation was more to try to encourage people to go to a mediation as a form of trying to resolve the construction disputes. I think that's admirable, because I think we can, you know, we've heard from the other speakers as well in the other sessions, they've all talked about the benefits of mediation, except that it's not that popular in Malaysia. For XYZ reasons. But I think in terms of a question that I wanted to pose to you, Lena, was assuming that one party's position is very strong, based on the contractual provisions, it's very strong. You go into negotiations with the other side, you will invariably not want to budge, because you know, you're going to be sticking to your grounds. You know that the other side is weak. How does the mediator or a facilitator deal with situations like that?
Because what you're suggesting is that you're only negotiating on one item, price, but you shouldn't be going to a negotiation and just negotiating on price. That's why I emphasize that you are negotiating on the interests of the parties. There are other things that you can offer that may be easy for you to give to the other side, but it's very valuable to the other side. So when you make an offer, you make a multifaceted offer. You address price, you could address timing of payment. I mean, there are many things that you can offer, and it depends on the actual dispute that you're dealing with and what you're trying to resolve. And you provide options. And so you go in there and you realize there may be some things that you're right, you refuse to negotiate on price or whatever, but there are other things you're prepared to give up. And so that's what I mean, where you make concessions and you offer things that are valuable to the other side, but easy for you to give. And you make this concession throughout, and you always offer, you frame your offer so that you're addressing multiple issues, and you can provide a couple of options. And I know I saw somewhere in the comments that, you know, someone said, what if the other side comes in with a very adversarial approach? They always come in to my negotiation with a very adversarial approach. And as I said, they're completely shocked when I do not have an adversarial approach, and it takes some time to win them over. But what I find is that if I just start by being me and by sharing information and being open, eventually they all come on board. They start off by being very suspicious, but you can build trust by actually sharing and giving them information that they never expected to get from you. And so if you set the tone of the negotiation and you start as the way you would like to finish, or finish whatever the expression is, then that will work.
Right. Rodney, I mean, what are your experiences on mediation?
Well, I was very fortunate enough to be the mediator in a very, very large dispute in Malaysia, which had a mediation provision in the dispute resolution clause, and the parties were obliged to go to mediation before they went to arbitration. And the lawyers appointed by both parties said, yeah, okay, let's go for it. How many days? 1 day enough? 2 days enough? Let's just go for it because it's not going to work. And the opposite happened. I wasn't a very experienced mediator then. I read all the books, I got prepared, and I very quickly realized that it was about the relationship between the parties, as Lena has been saying this afternoon. And just going on a point related to your last question, it may appear that there's an imbalance between the parties, but until you get there, until you find out what's actually on the table, a future contract, an existing relationship, you have to do your work hard as a mediator to understand the parties. And, you know, it can be great fun to get the parties in. And when you think at the beginning, you know, this is going to be whatever, and it turns out in a different way, it's all about that relationship between the parties. So I'm a great fan of mediation. I would encourage all parties during the contract and mini mediations to settle disputes. It's all about talking. It's all about keeping live the discussion, and not for a contractor or subcontractor saying, when he's been rejected, that's it, I have to go. Or even if arbitration has commenced, very many parties believe, oh, I can't talk to the other side because we're in an arbitration. That's not true. So I think mediation has great opportunities. And ironically, for somebody who comes from Europe, I've been here for 24 years in Malaysia, I found that Asian people generally mediate anyway. And very often they say, oh, well, we've been talking along the way, and there's no point in going to formal mediation because we've already done that. I don't agree with that view. I think formal mediation is slightly different and should be tried. And of course, what we have with COVID and so on at the moment, great opportunities to deal with these issues by mediation.
Yeah, but you know, I think a point has been made as well by someone from the floor that ultimately, at least from a Malaysian context, parties would have tried to negotiate a settlement beforehand, very, very often, many times, and it fails. They don't see the need to go for formal mediation because that's going to be the same thing as well.
Well, I would beg to differ on that, because the difference, of course, is we have the mediator, and I think good mediators work very, very, very hard and earn their fees. And I've seen mediators who, you know, come in and they don't work very hard, frankly, and it doesn't work and it fails. But the mediator can actually make a difference, I would suggest and argue. So it's always worth a try.
I just wanted to add, people think that, you know, making concessions or showing vulnerability is a sign of weakness. It's not. Showing vulnerability can be a sign of strength, but people are always worried, oh no, I can't show, oh no, I can't show my weak points, I can't show whatever, because the other side will take advantage of me. But they will find that if you make strategic concessions, which you might think is exposing your weakness, it will actually help bring the other side to the table. Once you've worked out that the other side is trustworthy, as I said, there's no point in negotiating with an untrustworthy person, but you know, most people are not untrustworthy, particularly if you are working together to deliver a project.
I agree. Ivan, yeah, I'm a fan of this up, met up, because what I've seen is after the arbitration starts and the statements exchanged, but more importantly, after the expert reports have been exchanged, very often, I think when the mediation comes in here to get parties to see it from an interest viewpoint, it narrows down and cuts down a lot of the issues between them. And then when they go back into arbitration again, it's quite settled very, very shortly thereafter. But many of the mediations I've seen, the forced mediations where you have to fulfill a contractual requirement before you go into arbitration or file for arbitration, I've not seen much success there. people just go through the motions. But this met up thing, yeah, I've seen a lot of success from that. Not sure what's Ivan, your view or Lena's perspective on that.
Yeah, well, unfortunately, we'll have to wait for another occasion to talk about this because we have run out of time. So all that's left for me to do is to thank the three of you. Thank you very much for your insights and experience, and also for the organizers for organizing such a wonderful conference.
That was an interesting session with so much good substance shared by the experts from Australia, Singapore, and Malaysia. Moving on, in conjunction with Turner Malaysia's 10th anniversary this year, we are pleased to have a special session just for this charity premiere with the country manager of Turner Malaysia, Mr. Wilson Lee. He will be sharing on the construction and ADR community as well as his organization's views and experiences in 10 questions.
Good day, ladies and gentlemen. Welcome to the Construction Claims and ADR Conference 2021, jointly organized by Legal Plus and L2 Icon. This is a special program, also part of our conference. Our guest here today is Wilson Lee, the country manager for Turner in Malaysia. Hi, Wilson. Thank you for being here with us today.
Thanks for having me, Cindy.
Turner first entered in Asia in 1965 and has become one of the regional leaders in providing construction services and technical expertise with offices in Malaysia, Vietnam, and Thailand. Some of your notable projects in Asia includes the world's tallest building from 2004 to 2009, which is Taipei 101, China's Central Television headquarters in Beijing, China, with 2 inclined towers connected by horizontal building elements at the top and the base, Bitexco Financial Tower in Ho Chi Minh City, Vietnam, Secrets Tower in Jakarta, Indonesia, Four Seasons Hotel in Kuala Lumpur, Malaysia, and the going to be tallest building in Malaysia and Southeast Asia, and the second tallest building in the world, which is our Merdeka 118. And this year, in 2021, Turner is celebrating 10th anniversary. So what thoughts and emotions come to your mind, Wilson, when you think about this?
Yeah, so we are a 120-year-old company, Turner Corporation as a whole, but 10 years ago, we came to Malaysia, and as you rightly mentioned, we celebrate our 10 years anniversary this year. And when we first came to Malaysia, we started here with only 5 people. And over the years, today we have more than 80 people and working on some of the largest projects in Malaysia. So, when I think about 10-year anniversary, I'm obviously very proud. And it's a very special year for Malaysia because our anchor project, which is the Merdeka 118 development, is structurally topped out this year. And so, 10 years we've been on that project, and it's a very significant milestone for the project and for the company. But when I think about the last 10 years, I will have to say that we owe it to our staff who've worked very hard with a lot of determination to make Turner where it is today and to contribute to the success of the last 10 years.
So what do you see as Turner's biggest accomplishment since your presence in Malaysia in 2001?
When we first came to Malaysia, our goal was to be the #1 provider of project management and construction services in the country. We also wanted to work on some of the most iconic and complex projects, because that's what we are good at. We also wanted to focus a lot on development of our people and be a locally led US company. And when I say locally led, I mean, we wanted to focus on development of our local staff and bring them up to leadership positions within the company. And, fast forward to today, we are working on some of the largest developments in Malaysia, Merdeka 118 being one of them. We have a presence at TRX providing claim services. And we also did the Four Seasons Place in KL, amongst other projects around Selangor and KL. And we currently also have a presence in Malacca, working on a project there with a large multinational client. So, we've come a long way, and these are achievements certainly to be proud of. In terms of our people, and developing local leadership. I'm testament to that. We are a locally led company as of today, and on not just focusing on local leadership, but we are also focusing on women participation in leadership and constantly looking out for opportunities for female staff, which is very lacking in the construction industry. There's obviously still a lot of work for us to do in that respect, but we are confident that the next 10 years will be better than the last.
That is a very sensible approach by bringing women back to the industry. As all of us know, construction industry is actually a very male-dominant industry. So I believe that you guys have actually taken a lot of efforts to basically involve more women participations in projects as well as management as well. So Wilson, before you joined Turner Malaysia in 2015, you were based in Australia. So what made you to come back to Malaysia to lead the team in Turner as a country manager?
When I first came back to Malaysia, I didn't join Turner as a country lead. I joined Turner as a project engineer, and I was doing a little bit of business development as well. But I worked on a residential project for one of a large developer here in Malaysia. And over the years, grew into the role of country manager. And I think, coming back to developing our people, I think that speaks a lot about our company and our strategy, that, when we implement a strategy to develop local leadership and provide opportunities, we do it, and we mean what we say as a company. And today we have local leaders leading our projects, and here as a country manager as well. And when I first came back, I believed one of the main reasons is obviously I believe in the Southeast Asia growth story. I saw a lot of opportunities in the growth potential of Southeast Asia and in Malaysia, and true enough, there are a lot of opportunities here to be had. So yeah, it's been a good move, and Malaysia is a good place to be.
I'm sure you have no regrets with your decision to move back to Malaysia?
No, absolutely not.
All right. As one of the youngest country manager in Turner International, how do you stand out among others?
By looking very young, that's obviously one thing that makes me stand out. But when you talk about being a young leader, I think one of the things that I face obviously is inexperience, right? Those are years that I can't have unless I have those years. But being young comes with disadvantages, but also with its disadvantages in this industry, where you see a lot of gray hairs in the construction industry. But I think one thing that I've learned is to learn to listen to people who are more experienced than me, to learn to listen from people who are experts in their field, who know a lot more than I do. And drawing from that experience and learning from that, makes me a better leader, and makes Turner a better company too. So as a young leader, I think the key thing is to listen to people who are better than you, in their field of expertise.
Okay, being a young leader, I suppose you must have a lot of innovative idea or new ideas that you have basically introduced to the company. So based on your experience, could you please share with us how project management processes have evolved throughout the years?
Yeah, I mean, there are a lot of processes and procedures for project management, and there are a lot of different schools of thought on project management in construction. But I think one of the key things that we see that is constantly evolving and constantly moving in the industry is definitely the use of technology and the adoption of technology in the industry. And Turner has always been an innovative company, even back when we first started. But here in Malaysia, we are using latest project management software to manage our projects. We use it to document notices, letters, progress, correspondences between project participants. And this being a claims conference, this is obviously a very important point to make. Especially when a claim arises, you don't want to be looking through printed documents and old files to form your case, but rather, when it's documented well on a cloud-based system, chances are your disputes will be better managed, or in fact, there'll be less disputes in the project. But touching on technology, internal, we also use BIM modeling. We do it in-house. We capture progress with 360 photos, drone videos that allows clients to monitor progress, to visualize progress, especially in a time like this when there are travel restrictions in place. All these types of technologies really come into play, and it's so relevant now more than ever.
You're absolutely right. Documentation plays a very important role in project management. If you have very good documentation system, if everything is properly recorded, you can actually avoid a lot of disputes. And it's actually a good process for dispute avoidance. And not to mention, when it comes to dispute resolution process, the differences and the disputes between parties will be properly recorded, and you actually have a stronger position in terms of arguing what was the mistake and what was the fault, and whose liability and whose responsibility are those. So now that you have touched on adoption of technology in the industry, is it one of the common issues that you have seen in the project management problems or challenges in the region?
Yeah, definitely. I think, the construction industry has always been one of the slower adopters of technology, and especially so in Southeast Asia, where labor is more easily available than other more developed countries. But I think the adoption of technology is key to this industry. The world is changing very rapidly around us. In Southeast Asia, it's also getting getting more sophisticated by the day. And we see a lot of Malaysian companies who are adopting technology and who are very innovative. But equally, there are a lot of companies that are also not doing that, and there is still a lot of work to be done in the industry. And what we tell our clients is that, especially if they're not ready yet, is that's where Turner comes in. We bring the technology to you, together with our international best practices in project management, and we do it so that our clients can focus on things that are more important to them as owners and developers.
I can see that this pandemic has accelerated digital adoption in construction industry. So as a company, what is the biggest challenge that you are most looking forward to?
Right now, I guess our biggest challenge is, maybe not unique to Turner and not unique to our industry, but really to the economy as a whole is business recovery. And we know that the past 18 months hasn't been kind to the economy and many businesses, but we are hopeful that this will come, that everyone will come out from this stronger than ever. But what we are looking at right now is looking at the future and looking at 3 to 5 years ahead and answering the questions of what we need right now, what we need to do right now to prepare ourselves for the next 3 to 5 years. So, industries that we see that are emerging, that we see opportunities in, we are upskilling our staff and hiring that skill set that we need in order to position ourselves for the growth that will be coming over the next 3 to 5 years. So that's really our challenge right now. And that's what we are focusing on.
I can see that you have very futuristic views over things and projects, as well as the aspiration for Turner. So 10-year anniversary it's a big milestone. So what would you envisage where Turner will be in the next 10 years?
I mean, we are here to grow, right? When we first came here 10 years ago, we had the intention of staying, and we have a very long-term view of our business here in Malaysia. So, we are certainly here to grow. We're not going anywhere. And, we currently have a presence in Selangor, KL, and Malacca. And, certainly we would like to grow in other parts of Malaysia, whether it's in the northern region, in a city like Penang, or whether it's in Sabah and Sarawak. So we want to grow from where we are to penetrate other markets, especially the data center markets, the healthcare markets, but also we started a claims consultancy business quite a number of years ago, and we've grown that business to be quite a significant business now, and we would like to continue growing that business as well, and to be able to serve clients in Malaysia from a claims standpoint.
Thanks for sharing about your, where Turner will be at in the next 10 years. That's actually a very interesting sharing. Let me move on to the next question. This is a question that your employees would love to hear from you. All right. If you could instantly fly all of your employees to any destination for a 10-year anniversary celebration, or suppose not just flying or bring them there, where would it be and why?
So for our 10-year anniversary, our plan was to have a big celebration together with our clients, our partners, the other partners that we work together with, our friends, and obviously our staff. Obviously, that's not and doesn't look likely to happen this year. We will probably still have it at some point in the future. But in terms of flying our employees anywhere, I think I probably have an answer that is not very popular. But what we will be looking at, and what I would love to happen is with the topping out of Merdeka 11A, a lot of our staff haven't had the opportunity to visit the top of the tower. So that's probably something that I would love to see happen, that our staff get the opportunity to see that and to experience being at that height. And with that kind of height is probably the closest to being able to fly right now.
I'll be very interested to be part of it as well. Let me know if there's any opportunity that I can actually be with you guys over there.
Sure.
All right. We have come to the last question for this session. Being a young leader, with what you have done in the past and currently, and your plans in the future, what is your life mantra or your belief that you could share with us?
My life mantra or my belief in terms of being a young leader and is to have balance. Work is obviously very important, and it's what keeps us going. It gives us purpose. But when we talk about life mantra or successes in life, I see that your home life, your family life. For me, it's being a father, being a husband, and I think those aspects of life feeds into being a successful leader. It feeds into being a good employee at work as well. And I think having that balance and being able to balance all those aspects of life is very key to being a young leader, or to be a leader, or just to be a normal employee, whatever it may be. I think just for life, that's probably quite an important thing, and that's what I go by.
You have absolutely spot on this. In fact, balance is the most difficult thing to achieve. For me as a person, I think no matter what we do, having a balance between work and life, family and businesses, we wear many hats in our life. For myself, I'm actually a daughter, I'm actually a worker, I'm actually a leader, and we are wearing different hats every day. So to have a balance with, in everything that we do is in fact the most difficult things, I must say. So to have a good balance in everything is in fact the most difficult thing to achieve. And I'm pretty sure that there are times that you basically struggle to balance between work and family, as well as yourself as a person as well.
Yeah, absolutely. And I think, I think at this time, this is also quite an important point to make in that leaders these days, especially with the pandemic, leaders have to be more empathetic, and I think that empathy part of leadership needs to come out a lot more, especially with a pandemic, with people in isolation and with mental health being an increasingly important aspect that we need to look at, and staff welfare, staff engagement. So yeah, you're right, absolutely.
Thank you for being sensible and thoughtful. I'm pretty sure that whoever works in Turner basically appreciate to have you as a young leader. Thank you very much for spending your time with us here today, Wilson. You're truly
You're welcome, and thanks for having me.
It is actually our pleasure to have you with us, and I wish you all the best in everything. Thank you.
Thank you.
Bye.
Bye.
Tonight's topic of discussion was interesting indeed, and I hope you felt the same way as well. Tomorrow, we'll showcase 5 speakers speaking on a variety of topics that are very relevant to the construction industry, with a brand new recording just for this charity premiere. Don't miss it.
In the city of Chongqing, a very beautiful city where my wife was born. So you can imagine.
My goal is to give you a snapshot of a case that is pending before the US Supreme Court.
As you can see, only with the cover letter and bills of quantities without supporting documents to justify the work done quantities claim.
As you can see, everything is indexed and you can navigate to a particular document quickly.
But the problem is, if it is just a dream alone is a mere puff, not this kind of puff like curry puff, but a mere puff.